Hi, this is Josh Blackman. I'm the president of the Harlan Institute, and it's my honor to welcome you to the Harlan Institute Virtual Supreme Court competition. This is the round of 8, the top 8 teams. And this year we are arguing the case of New York State Rifle and Pistol Club versus Bruin. We have the final match number 4 in the round of 8. So from Texas, we have Campbell Collins and Gabriella Lovins. And from Eden Prairie High School in Minnesota, we have Avik Garg and Zachary Kirkby. Petitioners, you have 10 minutes, begin whenever you're ready.
May it please the court. My name is Gabriella Lovins, and along with my co-counsel Campbell Collins, I represent the petitioners, New York State Rifle and Pistol Association, Robert Nash and Brendan Koch. The state of New York has denied petitioners' applications for concealed carry licenses under the proper cause section of the Sullivan Act. This denial is unconstitutional and the law is unconstitutional.
Would the court like a brief statement of the facts?
Please.
Robert Nash and Brendan Koch both applied for so-called unrestricted concealed carry licenses in the state of New York, but both of their applications were denied because of the proper cause statute in the New York law, which explicitly requires that applicants demonstrate a need for self-defense distinguishable from that of the
Counselor, let me interrupt you. Short of shall issue, is there anything that would actually satisfy your standard, or we have to go shall issue?
Well, Your Honor, yes, shall issue is the proper standard for Second Amendment.
Is it the only standard a state can adopt?
A state may set requirements to meet the shall issue, but yes, a shall issue is the only type of
what about good moral character? Could a state say we'll only give you a gun if you have good moral character?
Your Honor, that depends on how good moral character is defined, because there is historical precedent for requirements that only grant weapons for law-abiding citizens instead of, say, felons. But if the definition of good moral character is left up to the licensing officer, that would turn a Second Amendment right into a privilege, which would be unconstitutional.
I believe good moral character would have to be focused on something like past felonies. It can't be like, does this person lie? Do I think this person is loyal? Because those are far too subjective for a licensing officer to determine.
All right, so let's go to this issue of open versus concealed carry. Historically, which is there a stronger right for, open carry or concealed carry, just throughout Anglo-American history?
Well, Your Honor, the right protected by the Second Amendment is a right to bear arms for self-defense. So it does not specify whether concealed carry or open carry is the proper way to exercise.
No, but historically, is there more evidence of concealed carry being permitted or open carry being permitted?
I don't think there is one type of carry that has historically been favored.
The bans on open carry.
But wasn't it common law? If you concealed carry, considered kind of like mischievous and devious, you were afraid. Wasn't the preference at common law for having people open carrying?
I wouldn't agree with that premise, Your Honor. There's a lot of different thoughts about open versus concealed carry, but we see a lot of founding era evidence that concealed carry was expected. And
what's an example of such evidence?
Well, there was a trial judge around the time of the Boston Massacre who's been recorded telling British officers that the citizens there carried concealed weapons and under their clothes and would defend themselves if the need arose.
Now, it is true that the first bans on open carry came later than restrictions on concealed carry. So the first ban on open carry in the US was in Texas in 1871. And that does relate to the case before the court today because it puts prior bans or restrictions on concealed.
Was that in any way, was the Texas law in any way related to disarming the freedmen?
Yes, Your Honor. Many of the laws during that time were intended to disarm freedmen, but they have changed in the decade since then to be more of general restrictions for the safety of citizens. But the really important part of the Texas law is that it shows that when prior concealed carry restrictions were in effect, citizens still had a pathway to exercise their Second Amendment rights.
Didn't the Supreme Court in Robertson versus Baldwin say, in Robertson versus Baldwin say that prohibitions on concealed carry do not infringe the Second Amendment right? And I think in Heller, the court acknowledged that most 19th century courts to consider the issue said that concealed carry prohibitions are constitutional. So how do you square that with your position?
I think the important part there is there some method that citizens can exercise their Second Amendment right to bear arms?
So when concealed carry restrictions or bans are in effect, but open carry is still permitted, citizens can still exercise their Second Amendment right to bear arms. But that's
So
not.
I'm sorry to interrupt. Would your client be okay with an open carry if he was allowed, or if they were allowed to open carry but not concealed carry? Is that consistent with your position?
Well, Your Honor, possibly, because there's a distinction between, say in Heller laid out a distinction between carrying handguns, which are the weapon that's quintessentially chosen for self-defense, and carrying other types of weapons, and said that states can't prohibit the right of citizens to carry handguns, even if they can carry other types of weapons. So the open carry, concealed carry distinction would require a similar type of analysis. Is concealed carry the preferred method of citizens to carry for self-defense? And is there a compelling government interest in restricting concealed carry instead of restricting open carry? So we'd have to go back to the levels of scrutiny, and that type of change in restriction would need a different type of analysis, possibly under strict scrutiny or possibly under intermediate scrutiny, about the government interest in prohibiting concealed carry.
Well, but why does strict scrutiny demand shall issue? Like, how strict is strict scrutiny here?
Well, Your Honor, strict scrutiny is the highest level of scrutiny, and it's very hard to pass. A law
Do we
must
need to show least restrictive means, or is narrow tailoring sufficient?
It must be the least restrictive, the least discriminatory, and the most effective. So yes,
Well,
it does
there are different flavors of strict scrutiny, like Baskin Robbins, right? There are many flavors. Which flavor are we taking? Which area of First Amendment law are we going with?
Well, Your Honor, because the right to bear arms is so fundamental, and because it is a core part of the Second Amendment, the burden on the state is very, very high under strict scrutiny to demonstrate that this law is constitutional.
Yeah, I'd like to, you spent quite a bit of time in your brief talking about natural rights, that the Second Amendment codified it at pre-existing right. Where do I go to look up these rights?
Well, Your Honor, that specific phrasing of the Second Amendment is directly from D.C. v. Heller, in which the Supreme Court described the way that the Second Amendment protects and broadens a pre-existing right that was at the time.
You're asking us to apply strict scrutiny to this law, which means we have to take a really deep dive on what the government's compelling interest is going to be, and we have to weigh that against the nature of the fundamental right. And yet you're telling me that these rights are derived from natural law or something. Where do I go to find these natural laws?
Well, Your Honor, that is something that the framers of the Constitution were concerned with, because they were drawing on an Enlightenment tradition that you can protect your property or you can protect yourself. And one way that you do that is through self-defense. And Heller really established that the core of that Second Amendment right is a right to self-defense that was described by multiple commentators at the time of the founding and framing, such as William.
I'm just supposed to look to historical writings on the right of self-defense?
Well, we can look also to the Constitution itself, or I believe it's the Constitution, life, liberty, and the pursuit of happiness.
I think that might be the other one.
Yes, Your Honor, the Declaration.
Excuse me.
That's right. Let me pick up on Justice Kilmer's question, right? If we're going to natural law, right, shouldn't we have some more concrete basis in law than just sort of these penumbras, right? These emanations. Shouldn't we know that should be really sure that this right exists? I mean, let's talk about the Statute of Northampton, for example, right? I mean, how do you square your position with 800 years of history?
Well, the Statute of Northampton doesn't apply in this case because it restricted the offensive carrying of weapons rather than
common law. Wasn't it always a crime to carry offensively? I mean, isn't that part of the common law? I mean, so wasn't the statute really getting at something else?
Well, Your Honor, to carry, what the statute has always been interpreted as is a ban against carrying offensively. And that is not what we're dealing with today. We're dealing with carrying defensively, which is the core of the Second Amendment as decided by Heller and numerous historical sources.
You argued in your brief that the American right is broader than the English right. Can you explain what you mean by that?
Yes, Your Honor. So that's another part of Second Amendment concerns that comes from Heller. That was a decision that the court made in Heller, especially because the English Bill of Rights was protecting the right of only Protestants to bear arms. So when that right was imported into America, it was extended to people of all religions. And additionally, the Second Amendment specifically codifies the right of the people to keep and bear arms for their own self-defense. And that's really what the issue is here.
Well, the right was extended to all citizens, but not all colors, right?
That is correct. And that's something that was remedied in later years as more amendments were passed. And I see our time is up. May we conclude briefly?
Yeah, you may finish your thought. Go ahead.
We pray that this court will reverse the decision made by the lower court, render a judgment declaring the New York statute unconstitutional, and enjoin enforcement of the statute against petitioners.
You didn't even take a breath. All right, respondents, you have 15 minutes. You may proceed.
Thank you, Mr. Chief Justice, and may it please the court. New York's proper cause requirement for concealed carry permits of handguns falls well within the text, history, and tradition of the Second Amendment. We know this because of two lines of history. First, the Statute of Northampton, which evolved into surety laws, which evolved into the May issue permitting regimes of many states. Second, because bans on concealable weapons, carry of concealable weapons, was upheld throughout much of the states during the 19th century. I'd like to use this time to briefly respond to some of the historical points on the other side. First, they say that the Statute of Northampton is more limited. The problem is that they focus on the sort of offensive-defensive restriction. First of all, offensive-defensive supports our point, because if you can prove that you have a self-defense right, you have proper cause, then that makes it defensive. But second, they sort of, I guess in the brief, they focus on this dangerous and unusual weapons clause, and that's sort of what Heller looks to. The problem there is that the 1836 Massachusetts statute of surety laws, which is uncontestedly a broader scope than is a broad scope, uses that exact same dangerous and unusual weapon statute. The second point—
Let me interrupt you. Is there any evidence that people ever prosecuted under the statute of Northampton for peaceable carry?
Yes, in our brief, we cite Schoon versus Pito, where someone was prosecuted for that instance. It was not something where there was extra evidence found of provocation or anything like that. The mere act of carrying a dangerous and unusual weapon, which handguns are a part of, was found to be a crime.
Didn't the Supreme Court of North Carolina in State versus Hunley in 1843 say that the Statute of Northampton only applied to offensive carry, and that the ordinary act of carrying did not fall within it?
That is true, Your Honor, but before that, the police guidelines for how to prosecute the Statute of Northampton were very, very different. North Carolina did not require you to sort of show proof of provocation, but rather the police officer could find that you were carrying a weapon, and that would be sufficient. We think that this understanding is what was more common at that time.
What are the boundaries of weapons that can be carried that bring you within the Statute of Northampton? Is it only handguns?
We think that handguns, darts, knives, like those would probably be not allowed. We think that most weapons that could kill were probably closer to the dangerous and unusual line.
So if I'm an old man and I walk with a cane, but I also use it to fight off a burglar or a mugger, am I violating the Statute of Northampton?
I think that would be a usual weapon because a cane is something that's used for.
Okay, so but didn't Heller specifically find that handguns are common and ordinary weapons used for self-defense?
That was found in the context of home defense. I think when it's outside the home, that's dangerous and unusual. And I think.
Well, how does my right of self-defense change outside of my home?
Within the home, there has historically been much stronger protections for self-defense, such as standard ground laws and castle doctrine. Whereas out in the streets, it's much more different, and there is there's greater likelihood of intervention from, say, police.
So the police have no authority in my home to stop violence?
No, Your Honor. The police also can. Just there is historical precedent for much stronger protections within the home.
So are you saying I need more protection from my wife and children than I do from a mugger in the streets of New York?
No, you need more protection for your wife and children than you need when you're on the street. That's sort of what this.
Well, why do I need a gun in the house at all if I'm with my wife and children?
The argument is that you need a gun to protect yourself from burglars, and that right has always been more sort of pronounced.
So burglars are more dangerous than a street robber.
I'm not trying to contest the rationality of this. This is how this law has been enforced. That's how the law still is enforced with the Castle Doctrine in the states today.
Well, if you can't contest the rationality of the policy, then how are you going to meet any level of scrutiny?
Yes, Your Honor. I think there's a difference when we're talking about this sort of, I think we've kind of gone down the rabbit hole, but if we kind of return to the statute of the proper cause requirement, we are outside, right? Because we have proven that there's a reasonable fit between a may issue state, a permit regime, where a shall issue permitting regime would not get rid of crimes committed by those who have not previously committed felonies. And our brief on page 15 explains that that is the majority of crimes committed by handguns.
Well, Counselor, but why would a shall issue regime with a robust background check and perhaps training and safety certifications not meet your standard?
Well, Your Honor, this would only look to people who have clear background issues that may lead to violence. It does nothing about first-time offenders or people where these conventional background checks would not immediately detect violence.
But do we usually condition the exercise of constitutional rights on such vague notions of, do you have a good enough reason? Do you really need that abortion? I mean, is it really going to, I mean, do we usually ask that in any other constitutional context?
Well, the First Amendment, in order to get a permit to protest, as one does need a permit to protest, does determine the time, place, manner.
But not the justification. It's like, well, we'll give a permit to Republicans, not to Democrats. That won't fly.
I mean, similarly, if this not like this content neutral thing applies here too, if it's because of a personal characteristic and not because of proper cause, you can appeal up the chain and you can say that I had proper cause to carry the weapon, and that court needs to give me the permit.
But I get it, but the courts are still considering the same subjective standard. They're not going to second guess it, right? Do we usually ask when do you really need to exercise this right before they exercise this? In any other context you think of where we have that standard?
I mean, I just respectfully, Your Honor, I think that the First Amendment does have that standard. It is a subjective determination by a judge, and if an appeals court wants to reverse, they have to make the exact same findings of clear error.
I think what Judge Blackman's trying to ask you, and if I'm stepping on his line, he'll tell me. For example, does a priest or a preacher or a rabbi have a greater right to worship God than, say, a layperson under the First Amendment? Is there such a classification of people who are particularly suited for exercising a right under theology than there would be under self-defense?
I think that there's justifications, right? That you have to justify that this time, place, manner justifies it, right? Similarly, you have to justify that your time, place, and manner for your self-defense restriction justifies that, right? I think it's very, very similar in sort of that situation. It's not saying that you, because of your characteristic as a Jewish person or as like a Christian, would mean that you don't get the right to self-defense.
That wasn't my question. I wasn't talking about the difference between the religions. I was talking about the difference between a church leader or a person who's a professional theologian. Do they have a greater right to worship under the First Amendment than anybody else under the Second Amendment? I'm using the Second Amendment as an analogy.
Maybe I'm not seeing your analogy, Your Honor, but I'm saying no, but I think the similar thing applies here. No one has a lesser or greater right to sort of own a gun, but you have to show proper cause that this sort of situation justifies it. And that is like a neutral sort of test that is applied to each person equally.
So a rabbi is entitled to a permit to preach in the public park, has a greater need to preach in a public park than I do if I'm not a rabbi. Is that what you're saying?
I think that again is a classification based on the person, not based on a neutral test. And I think
I've stepped on Judge Green long enough. I'm sorry.
Oh, sorry. Well, I was gonna build on that, and maybe I should let it go. But if the government said nobody can go to church unless you prove to us that you're especially devout, would that be constitutional?
No, Your Honor, that would not be constitutional, as that is clearly violating the establishment clause and preventing people from the free exercise of their religion.
And I think the history.
What about you only get an abortion if you show good cause? That maybe you're an abusive family, and there's a risk that you might the child might be subject to abuse. I mean, would that be sufficient? Can government do that?
I guess the difference here is the history, right? There is history in surety laws of allowing these good cause restrictions, and I think it makes sense.
Are you saying that the Second Amendment is different from other rights? It's sort of inferior, second class to abortion and religion?
No, I think just as every right has their restrictions, the Second Amendment has their historical restrictions. It doesn't have the same historical restrictions as the Fourth Amendment, which is limited sort of less to cars than it is to homes, but it has its own restrictions, and those are historically justified.
So even with surety laws, speaking of those, even if you had to pay the surety, you could still keep carrying, right?
Yes, Your Honor, but I think that still proves that those laws, if petitioners are correct, would violate the Second Amendment. So if the petitioner's stance is correct, then no matter if it's a fine or prison time, it's the same sort of Second Amendment analysis.
But that wasn't for everyone. As I understand surety laws, you could carry, and then if you did so offensively, then you had to pay a surety. And then once you pay that, you could continue to carry. Doesn't that prove that there's actually a right to carry?
I don't think so, Your Honor, because you'd basically be subject to your neighbor's determination. If they thought that you were carrying offensively, then they could force you to pay that surety, which would violate sort of any sort of.
Well, they'd have to prove it to a court, just like if you wanted to get a restraining order against someone, you have to go into a court and prove that you actually need it.
Respectfully, Your Honor, I think it's the other way around. You had to prove to a court that you had good cause if your neighbor complained.
So let's.
Do you lose if we apply strict scrutiny to this case?
Yes, we lose.
Yes, Your Honor.
Well, let me ask a different question. What if New York had a policy that said you're allowed to carry a gun if you pay for an insurance policy, basically a modern day surety, right? Where you're required to keep a liability policy that if you use this gun for self-defense, the insurance company will cover any costs from your use. Would that be consistent with history? Basically a modern day surety.
I think if you did a strict scrutiny analysis, that would probably uphold if that's justification.
Oh, you're saying intermediate. So would that could New York do that under intermediate scrutiny?
Yeah, I mean, if I think the gun policy was saying that maybe like.
So wouldn't that be a more narrowly tailored way of accomplishing this goal? I mean, but isn't that something you could do instead of the good cause standard?
No, Your Honor, because the similar scrutiny restriction would not apply. Insurance has use, right? That you use this gun in self-defense. Now you have your legal costs paid. The government can require that. When you're paying a surety for no reason other than just like an administrative thing, then that check would be something that violates the Second Amendment.
Right.
Could I ask one more question about? Sorry to get caught up on the history stuff, but just the petitioners argue that the English right was more narrow than the American right. And to that end, they pointed to the text, and there could be something there. The English right protected the right to have arms, whereas the American right protected the right to keep and bear arms. So even if historically England, taking your argument as fact that, let's say you couldn't carry there, doesn't the fact that the Americans codified the right to bear arms within the text of the Second Amendment, does that indicate that they intended to protect the right to carry guns?
Well, Your Honor, the U.S. Constitution is more broad than the English Bill of Rights, but as Heller had put it, no right is unlimited. Just because the right to keep and bear arms are on the same line of text within the Second Amendment doesn't mean they have equal power. When we look to the Fourth Amendment, protections from search and seizure within one's home is much greater than that of their car. For the Fifth Amendment, the process of depriving one of their life is much harder than to deprive them of their property. All of these are on the same line within the Constitution, but they have differing strengths.
And I think just to add to that, when you sort of look at our history, we're not using English history. We're talking about history in the colonies. We're talking about surety laws in the colonies. And I think that proves that you don't need to use the English Bill of Rights to say our history doesn't matter.
Were there any prohibitions on carry in the colonies?
Yes, Your Honor, there were prohibitions. We cite State versus Andrews, which is a prohibition on carry of concealable weapons specifically. And we think that case shows that concealable weapons are different. And I would like to quickly respond to just like petitioner's point. They make the argument that they'd be happy sort of with any ability to carry. And I think that New York does allow it because while New York City has a ban on open carry of rifles and shotguns, when you go outside of New York City to sort of Rensselaer County, where
people in New York City have less constitutional rights, should they just be second-class citizens? They have to live in a dense area.
I think if this court finds that the proper cause restriction is unconstitutional, then maybe there should be another case from New York City. But as it applies to this petitioners and Rensselaer County, the fact that concealable carry is something that can be restricted, like concealable weapons carry of those can be restricted, means that the fact that open carry of shotguns and rifles is allowed in Rensselaer County means that sort of is a second argument from which you can affirm this case.
Well, is the state prepared? Suppose we send you back to the trial court, and you have to try this case. Is the state prepared to prove that New York has a lower crime rate than the woods and fields of Rensselaer County?
Well, Your Honor, the idea is that in woods and fields, there is any instance of crime is much more likely to be significantly more dangerous, whereas in a city, there is much more likelihood of intervention and for the crime to just not escalate to an as dangerous level as when one.
Are you suggesting that the per capita crime rate in Rensselaer County is higher than New York City?
While we don't have statistics, I guess our broader point would be that if you find proper,
shouldn't you? You're the government. You're telling me that you have a justification for this policy.
I think, Your Honor, that the argument we're making is that proper cause requirements are fine, right? Even if Rensselaer County did the same thing as New York City, that would still be fine. I think if you find that proper cause requirements aren't allowed, then sure, New York City's law falls. But we're saying with respect to this case, it is sufficient to say that concealable carry, they have an avenue available, and that's like a reason to affirm the Second Circuit. I see that we're running out of time, so.
Thank you so much, Counselor. Thank you. All right, petitioners, please, you have 5 minutes for rebuttal time whenever you're ready.
May it please the court. I'd like to address 3 points respondents made. First, Heller outlined the core right of self-defense in the Second Amendment, and it is for all the people, not an unspecified subset. Second, handguns are the quintessential self-defense weapon, and it's not sufficient to say you can use rifles but not handguns. And third, general self-defense is not considered a good enough reason in New York, and you shouldn't have to opt in or prove yourself to earn your constitutional right.
On that point, Counselor, if we decide to uphold the statute and say that New York's statutory regime is fine, but they must apply a definition that this court imposes on the statute, that proper clause includes the ordinary right of self-defense for all citizens. Does that satisfy the complaint that your clients have lodged?
Well, Your Honor, if it said the ordinary cause of self-defense, then yes, because that's giving the core Second Amendment right to all citizens. If they have to prove that they have the ordinary need for self-defense, then the system is still broken.
So your objection is to the burden shifting, the fact that the citizen has to prove that they have a need rather than the government has to prove that they don't have the need. Is that your position? So if we shift that burden by changing the definition of proper cause to a default that self-defense is proper cause, you win, correct?
Yes, Your Honor.
Well, let's say that we had a different regime. We build on Justice Kilmer's question. Let's do burden shifting, right? Let's say it shall issue with rebuttal presumption, right? So the presumption is you get the gun, but the sheriff in the local county digs up information saying that maybe this person shouldn't have it. Can the government shift the burden back to the applicant saying why he really does need it after some presumptive, some reason it's not a criminal conviction, but something else that might be a good reason? Would that work?
Well, Your Honor, that gets a little tricky. If this person has a history of perhaps severe anger issues to the point he has
depression. Let's say he has a history of depression, right? No history of violence, but the sheriff learns his subscription for Prozac. He's got bad depression.
I don't think a subscription for Prozac is good enough, but perhaps there has to be some sort of mental wellness check.
And Your Honor, that's
Would you be okay that before you get a gun permit as part of your background process, you have to sit in a couch with a psychiatrist for an hour? Would that be enough?
Well, Your Honor, if the intention is to determine possible mental illness, which is there are longstanding prohibitions on the ability of citizens.
No, I'm not saying mental illness, saying just depression, right? You go to a shrink and he says, "Yep, you have clinical depression. You need to go on some sort of depression medication." People with depression have a high rate of suicide. They can use a gun to hurt themselves. Would that be sufficient? Could you add to a shallowish regime? You cannot have a gun if you have clinical depression.
I think that would be up to the legislature.
Well, no. We're asking the courts. New York enacts that laws. We strike that down.
Then yes, Your Honor, that would be more likely to be constitutional because of the way the law operates.
All right. So your opposition is subjectivity. Isn't giving a shrink the power to deny a constitutional right very subjective, almost as bad as good cause?
Well, really, our opposition is to the fact that the New York law makes you justify your reason to bear a weapon instead of limiting
So a
certain.
person who faces risks walking to work can't do that can't defend themselves because they have depression, right? So people with depression are now out. They can't defend themselves in a rough neighborhood.
Well, Your Honor, it really comes back to that longstanding mental illness laws, and you're correct. We're getting into murky waters because there are different levels of depression. Some people have much lower levels. Some people are suicidal. So there need to be clear standards as to who falls under the mentally ill cannot receive a gun standard, because we don't want to take the guns out of people who have a reasonable need for self-defense and don't have a possibility of harming themselves, or an above average possibility of harming themselves or accidentally harming others because of mental illness. So we would need clearly defined standards, but that's not what we have to decide today.
I had a quick question about strict scrutiny. The respondents conceded that they would lose under strict scrutiny, as I understand it, but I'm not so sure. Can you give me an example of a less restrictive alternative to this law? I mean, this gives everyone an opportunity to carry as long as they just satisfy, what the government wants. Isn't that?
I mean, you can answer this question. Go back past your time. That's fine.
Yeah, I'm sorry. I led you into that. I led you into trouble there. I'm sorry.
Well, yes, Your Honor, there's several possibilities that could be enforced instead of this. For example, training. We briefly talked about mental illness. Perhaps you do have to visit a shrink. You have to meet background checks. There's several things they could do to prevent felons or violent criminals from getting guns while still giving general people with a general need for self-defense their right to firearms, because it's a right, not a privilege.
All right. Thank you so much, Counselor. Thank you.
Thank you.
All right. I'm going to call time. The case is submitted. If the you're on camera. That was a level that I haven't seen so far. Just the two of you. I've seen good teams, but the two of you head to head was at a different level. What I loved was you were so familiar with the other side's arguments. You anticipated their arguments and you responded to them. Said, "I have three responses. 1, 2, 3. Boom, boom, boom." And he said, "No. They on their brief they said this," and you just had such a level of preparation that you usually don't even see at the Court of Appeals, maybe the Supreme Court, but you had such a level of preparation that was really truly remarkable. You're all four of you are gifted. You have a gift. This is not something that you're sort of born with. You have something unique and you work on it so hard. And it's really stunning. I don't have any negative feedback. I've given you all the positive, but this was a really strong round, and I'm so proud of both of you, both teams.
Let me echo that. I was impressed with the level of advocacy. You weren't just making an argument to the court. You were making an argument to the court and saying why the other side was wrong.
Yeah, effortlessly. Yeah.
I don't have too much to add to that. I was trying to, when I went into this, I was thinking I was going to give you like some good things you did and at least one thing to improve on, but you guys all did so well. It's really hard to come up with. I'd just be making something up if I were trying to come up with something to improve on. You guys did great, and I guess just to repeat, made your points and then focused on, a lot of people, it's very tempting to come in and just say whatever you wanted to say and what you were planning to say. And you guys both did an outstanding job of saying, I want to address these 3 points that the other side said. And
let me
really
some
well.
specifics. So for Avik and for Zachary, the surety laws, you had such a strong command that area. Joseph and Don actually litigated this. Your command was so strong on that area. That's an arcane area of law, right? I don't think I even understand it myself, right? But you had such a command. You're saying, well, the Massachusetts statute, blah, blah, blah. I mean, that level of depth shows how much research you did. You can just walk into this. And for Gabriella and Campbell, the mental illness one, you towed that line carefully because you avoided my trap, right? My trap was Heller said mental illness. And you tiptoed around that one so carefully because you didn't fall into the trap. I was trying to trap you because you said no to mental illness. I'm going to hit with depression, hit you right with mental illness and Heller. So again, it's good that you sort of in person, you're right next to each other, but you handed over smoothly from 1 to 2, right? This was a very smooth transition. I didn't feel like Don, Joseph, like either was monopolizing. I think you both had a pretty good
Oh, no,
balance of the distribution of the workload. Some of the other teams had difficulty with that, where one was sort of hogging the time. I think both of you were pretty smooth, left, right, 1-2, which is not easy, because usually when you're a lawyer, you don't argue two. It's just one person up there at a time. But I felt it was smooth. You didn't contradict each other. You didn't say, well, let me clarify what my other person said, right? That's always tricky, because I was like, wait a minute, maybe my friend's not doing the right thing. You're respectful. When we interrupted you, you sort of shut up right away. You didn't start talking and trying to go. A couple of times, I think you said, oh, it's tricky or it's murky. Look, these are hard questions, right? And one thing you can say is, Your Honor, these are really murky issues, but the issue is a lot easier, right? Our issue is simpler. And that's when we can always pivot back. Don, not negative, but just any sort of tips that you might give them, because and Joseph also, you've been arguing cases for much longer than I have, because I've never argued anything. But
I'll
anything
let Joseph go for. I do have a comment that I'll let Joseph go first. I don't care.
Okay. Well, I would have liked to have heard a little more from Zachary. Although I understand when you're engaged, especially it's a weird format, and then when we're asking questions, I understand it's hard to switch partners in the middle of that, but I would have liked to have heard a little more from him. And then I guess that's all. I guess that's the only really criticism I have.
This is a criticism of the respondents. I think you gave up too quickly on strict scrutiny. I think you could have made an argument that your statute could survive under strict scrutiny. Maybe the best example is the First Amendment protects speech and print, yet the courts have no problem finding fraudulent speech or solicitation to commit a crime or even conspiracy to commit crime, which is usually conveyed by speech or text or written words. Now, of course, the courts deal with it in a different way. Sometimes they just define it as non-speech. Okay, but the point is that there are instances even under First Amendment law where strict scrutiny won't will still uphold a crime. Okay, so I think you gave up the ghost a little bit too early on that.
Yeah, maybe one way you can do it, and see, maybe it's my bias showing. I think under strict scrutiny the government loses, but maybe one we can say is, Your Honor, we think the plaintiff or petitions will likely prevail under strict scrutiny, but here's some arguments to the contrary. Maybe that might be one way, so you're not fully conceding it. But I think if you're pressed, and this I think let's get to Gabrielle and Campbell, is it least restrictive? I'm sorry, my microphone fell. Is it least restrictive means? Is it narrowly tailored? There are many different flavors of strict scrutiny, right? If it's least restrictive means, I think you lose. If it's narrowly tailored, you probably lose, but it's a little bit, you have some more give and take. So just think about it. I mean, it's ultimately it's a strategic decision. Sometimes if you realize you have a losing argument, just give it up and move on. Because you don't want to get bogged down and have all of your 15 minutes sucked up by that one issue. So it's a strategic choice, but you can massage how you're conceding that point.
The respondents, I thought you guys did do a good job of conceding that the American right is broader, but you still address the argument very well by saying, I'm not talking about what happened in England so much. I'm actually talking about how those same statutes were applied in colonial America. I thought that was a really good transition because I was trying to kind of corner you into England in the English history. And so you did well with that. And also, while I'm at it, you did very well with explaining that the Fourth Amendment has different levels of protection, and Fifth Amendment has different levels of protection, because that's a tricky issue. Like, why is there a lesser right than keep? And you guys did well with that. I think that's a hard one to address.
And by the way, tiers of scrutiny is a real tricky area of law. There are sitting Supreme Court justices who don't even like the regime. Okay.
All right, great. Questions for us? What do you want to ask us?
Yeah, so one thought, like on the sort of scrutiny issue, do you think it's like okay to sort of pivot to sort of like intermediate scrutiny at that point?
Yeah, and I think you're on much stronger ground for intermediate scrutiny. I think that's right. Yeah.
The other question, just like, how do you think, like, do you think it's correct to sort of say scrutiny shouldn't apply if we're correct about history? Or like, how do you think about that issue? That's one I was.
Well, it's really hard, and maybe Don and Joseph can opine in this one yet. The Supreme Court has not given us much guidance on how text history and scrutiny relate. A lot of this is developed in lower court jurisprudence. And I think one of the benefits of this New York rifle case might get some clarity on this issue, right? Probably not because they're a bunch of squishes, right? But I think we might get some clarity. Joseph's laughing, right? But I think you have to sort of do an all the above approach. Your Honor, we went under text and history, we went under scrutiny. I think that's got to be the government's position. And the other side says we went under text and history and also under either tier of scrutiny, heightened or intermediate, we win. I think that's got to be there. These are lines that you have to draw.
Plus, you have to sort of be a little bit careful too, because law school and studying the law and studying the Constitution, people get what I call scrutiny tunnel vision. Okay, the fact is that we apply tiered scrutiny to certain parts of the Constitution, and other parts of the Constitution we don't pay any attention to that at all. I mean, can you imagine somebody who's 24 and a half years old, who's won a seat in an election for Congress, but the Constitution says you have to be 25 to sit in the U.S. House of Representatives? I don't want to know what level of scrutiny you apply to that. You know, if the law says you have to be 25 years old, we don't start talking about rational basis or strict scrutiny review. It's just, no, you're not 25. You can't sit for Congress. Okay, so that's where we get to. That's sort of a controversy over tiers of scrutiny and text history and tradition that it appears the Supreme Court used in Heller. So, text being the first analysis. So, again, as Josh said, you have to be well versed in all constitutional methods of constitutional interpretation, but it's also a good idea to be able to pivot from any one of them.
Thank you.
Any questions from petitioners? Gabriella or Campbell?
So we've been talking a lot about the concealed carry versus open carry issue. And I know last time we said if you can open carry but you can't concealed carry, that's all cool. So we've been thinking about that, and I have a theory, and we kind of towed the line, and I'm not really convinced that I'm right, but I want your opinion. So Heller says handguns are the quintessential self-defense weapon. So we were wondering if there might possibly be an argument. I don't think it comes much into play this case, but that concealed carry or perhaps open carry is the quintessential self-defense manner of carrying a weapon.
So what do you think about that one? That's your ballpark, I think.
I don't think you'd want to argue that as the petitioners, because historically open carry was always favored. I mean, whenever one was prohibited, I mean, perhaps every single time, at least in the 18th and 19th centuries, whenever one method of carrying was prohibited, it was concealed carry, because open carry is more common. And the thought was that if you were going to conceal carry, you were hiding something, you were up to no good. So I think historically there's a stronger argument, like if you could only have one or the other, I think there's a stronger argument for open carry, at least looking at the how the courts interpreted the rights in previous centuries. So I don't think as petitioners you would want to really make that case. I think there's a much stronger case for the respondents to say open carry is the right, concealed carry is not. So this law is
open carry is a trap. It's a double-edged sword because it helps. I think the position you did take, that if the New York State allowed open carry, you guys would be happy. I think that's actually I think Don and Joseph, I think that's the good position to take.
Yeah, I think so.
Yeah,
I'm sorry.
What ends up happening is then the legislature says, "Oh crap, we have to allow everybody to open carry." And there's a difference between open carrying a gun, in a one-horse town in Montana, nobody cares, okay? But if you're openly carrying a gun in the subway in downtown New York, people are going to freak out, okay? So there's a different response that has to do with, public order or not causing a riot or something like that. Even if nudity could be a form of expression, and that's not necessarily a lock under First Amendment law, we don't allow public nudity because it causes a problem, right? So things that cause people to get excited and riot and do crazy stuff in public, the government has some ability to control it. So the legislature, the whole idea of getting some form of carry legal everywhere and saying open carry you're fine with, it's almost like you're calling the legislature's bluff. Then the legislature has to decide, oh man, do we really want people open carrying guns in downtown New York? No, then they'll be forced to create a concealed carry regime.
Yeah.
Thank you. That's very enlightening.
It's not my argument. The genius of that argument was a colleague of mine named Alan Gura.
Who might be one of our judges in the future. I don't know. We'll see.
Oh boy, you guys are in for a treat if that happens.
I'm working on it. All right.
You're arguing McDonald, right?
Yeah.
Okay.
And Heller.
It's actually sad. I was going to invite Walter Dellinger to guest judge. He argued Heller on the other side. And I seriously was going to email him. He died the day I was going to email him. I feel dreadful about that. Like I was going to email him that day and like he died. And like
Don't email me anymore, Josh.
oh man, Don, I'm never email you ever again. Yeah, anyway, we'll see. But both teams were really special, really stellar. You'll I mean, I've told you for your bright futures, you have no limit what you're going to accomplish. I'm just so excited to see what you pull off. Make sure you come back and tell me what you do in a couple of years, okay?
May I ask a personal question of the petitioners? Is the name of your school homeschool, or were you homeschooled?
We are homeschooled.
Okay, thank you.
Yeah, I had to actually change the thing because the software didn't actually have a thing where every student had to attend a school, so I had to put something in the blank. So that's why I put
Okay.
like it was a required field on my software, so I had to put something in there. Anyway, that's what we have. We'll announce the scores later today or tomorrow. But I want to thank you all. We'll be in touch soon. But congratulations again, and always feel free to reach out if I can be of any help to you.
Thank you so much.
All right, with that, we're adjourned. And if the students can sign off, I'll talk to the judges for a minute. I'll stop the recording. Bye-bye.